The civil procedure fact pattern from July of 2001 is another reasonably straightforward, and to my way of thinking, reasonably easy California bar exam essay question. There are one or two issues in here that you might be able to learn a detail or two of law about, but by and large, this is a run-of-the-mill question testing pretty standard issues in a fairly standard way. Take a look at the call of the question. 3 quick questions. 1. Was the trial court correct in denying the motion of Don's Market to dismiss the complaint on the ground that the court lacked subject matter jurisdiction? Discuss. Well, jurisdiction is the most commonly tested issue on civil procedure essays, and it's pretty simple. We will break it up into its pieces, connect the facts to the pieces, and then make a decision about jurisdiction. 2. Was the trial court correct in denying Rita's motion for a change in venue? Discuss. Well, this is the somewhat unconventional issue in this fact pattern. We don't see a lot of venue issues, but they do come up now and then, and it's well worth knowing about. When I hear the word venue, what I think of is not the correct jurisdiction, but really the correct courthouse. Are we in the right building for the dispute? Is it fair to the parties for them to show up at this particular building as opposed to some other one? So for venue issues, we handle them in a way that is rather similar to jurisdiction. We look at the facts surrounding the dispute and we ask ourselves, is it fair to require the litigants to have their dispute heard in this courthouse? Next, we turn to call of the question number 3. Was the appellate court correct in dismissing Rita's appeal? Discuss. Well, appeal is another issue that does not show up terribly often on California bar exam essays, but it is pretty simple and straightforward. We know that the most basic rule with regard to appeal is the final judgment rule. So we'll look at the facts. We will come to some conclusion with regard to the appeal. Please go to the top of the question. It's a fairly short question, but not as difficult as many of the shorter questions. Paragraph 1 is the longest paragraph, and it gives us most of the important facts about jurisdiction. Anytime you've got a paragraph that refers to State A, State B, and State C, we've got to keep track of who the different players are, and we know that we'll be dealing either with diversity issues in federal court or a long-arm statute and minimum contacts in state court. We take a look at paragraph 1. We meet Pam. She has taken an indefinite leave of absence, sublet her apartment in State A, and gone to care for her elderly mom in State B. 6 months later, Pam is walking to her car in the lot of Don's Market in State B. Rita, a State C resident, hits her with her car, and Rita's got 3 passengers, all from State C. They're traveling through State B with Rita. The police officer is called to the scene. Pam is allegedly reading a magazine as she is walking across the parking lot and therefore wasn't watching where she was going. Pam, our plaintiff, tells the police that she had just walked out from behind a big concrete column when Rita's car struck her. All right, there's plenty of facts about the dispute and where everybody is from. In paragraph 2, we learn about the lawsuit. Pam sues Rita and Don's Market in federal court in State B. The complaint sought $60,000 in damages against each defendant, and it asks the court for an injunction requiring the market to tear down the concrete column that Pam is arguing was partly responsible for her injuries. In paragraph 3, Don's Market moves to dismiss on the ground that the court lacks subject matter jurisdiction. The court denied the motion, and that's the topic in call of the question number 1. Well, we're going to have to analyze the facts fairly carefully here, but it looks to me as if the court correctly denied this motion to dismiss. Because it looks to me as if we've got a reasonable diversity case with diversity of citizenship and a reasonable amount in controversy once we aggregate the claims to include the cost of removing the concrete pillar and equitable relief part of the complaint. In paragraph 4, we find out about Rita's motion for a change of venue. She wanted to go to federal court in State C because she is a citizen of State C, and it would be a hardship for her and her witnesses to travel to State B. That's going to require perhaps our most careful analysis of the facts, but the bottom line is it looks as if the trial court was correct in denying the change of venue motion also. Finally, in the last paragraph, we see Rita filing a notice of appeal of denial of the venue motion, and the appellate court dismisses the appeal. That gives rise to our third call of the question. So, as I said up front, this is a fairly straightforward question, and to my way of thinking, a comparatively easy one. Please turn the page and have a look at my outline of issues, and you'll see once again I follow my own advice. I apply the basic approach to civil procedure here, and as usual, it allows us to break the issues up into pieces, and then we can handle these bite-sized pieces with similarly sized analysis below. So please look at the outline with regard to the first section, the denial of the defendant's motion to dismiss. I explain up front that Pam's claim is not a federal question, like, for example, a copyright dispute or a dispute arising out of the federal civil rights laws. So we have to focus on diversity. I have a separate section on diversity and the amount in controversy, and I conclude that the trial court's denial of Dan's motion to dismiss was correct. So here, we're not doing anything particularly clever, but we are being workmanlike. We know what the law is. We know how to analyze the facts. We don't waste time. We just do it. Move on to the trial court's denial of Rita's motion for a change of venue. Here, I first focus on venue in State B. Then, perhaps the most intricate analysis in the answer, as we'll see in a moment, venue probably is going to be problematic in State C because the defendant, Market, doesn't really have any contacts with State C. The bottom line is, I conclude the trial court's denial of the change of venue motion also was correct. Finally, we turn to the appellate issue, and here again, I think the courts are making correct decisions in this fact pattern, a rather stark contrast to the conduct of the judiciary in certain other civ pro fact patterns. But here we're not doing anything very counterintuitive. All we're doing is following the basic approach to appeals that we know from our standard format for approaching civil procedure. We deal first with the final judgment rule. We raise the issue that perhaps this would be fit for an interlocutory appeal, and in either case, we conclude that the appellate court's dismissal was correct. All right, fair enough. This is not a complicated fact pattern to interpret. It is not a hard answer to organize. But in a couple of places, this is not the easiest answer to write. So let's take a quick look at my answer, and I will direct your attention to one or two highlights. Up front, look at the very first paragraph in my answer. Once again, I lead with the facts. I explain the factual context of Dan's motion to dismiss. You'll notice I do it in two short sentences. I'm not merely repeating the fact pattern. I'm citing relevant facts to set the stage for the analysis that follows. Next, we turn to the tort claim of Pam. I explain the facts of the accident, and I indicate that this is not a federal dispute. It is a tort claim based on the law of State B, and so no federal claims. That requires a diversity jurisdiction analysis, and here I actually insert a little bit of law. I explain the law and the legal requirements of diversity jurisdiction. Then I just follow through element by element, connecting the facts to the law. First, we focus on diversity of the parties. And here, I've got a little short paragraph for each of the three different parties to the dispute. I explain their citizenship. Next, we turn to the amount in controversy. And here, again, I have to spend a little time with the facts, aggregating the claims, but ultimately, I conclude that there is a sufficient amount in controversy to justify diversity jurisdiction in federal court. And so my conclusion is that the trial court's denial of the defendant's motion to dismiss was correct. Next, I focus on the trial court's denial of Rita's motion for a change of venue. Here again, up front, I lead with the facts and provide a couple of sentences of context to explain the analysis that's about to follow. Then, I focus on venue in State B federal court, and I explain that venue in State B appears to be appropriate. Next, I focus on venue in State C. And here you'll notice I provide two paragraphs of analysis, the second of which I think you'll agree is quite analytical. Have a look at these two paragraphs, because to my way of thinking, they are the real heart of this answer. These are the two paragraphs where I show you and a hypothetical examinee would show the examiners a clear understanding of how these jurisdiction rules really work. What we're trying to do is establish the most appropriate, fair location for this dispute to be heard. And since venue is probably going to be improper in State C, and all of the facts really are pointing our attention to State B, I conclude that the trial court's denial of Rita's motion for a change of venue was proper. Finally, we turn to Rita's appeal. Here again, I have a couple of very short sentences where I lead with the facts and set the stage for the analysis. I focus first on the final judgment rule, indicating that most appeals are improper until there's been a final judgment on the merits. Next, I indicate that interlocutory appeals are sometimes appropriate when a specific issue has been fully litigated that affects the remaining issues of the dispute. And jurisdiction issues sometimes are appropriate for interlocutory appeals. Here, I think it was correct for the appellate court to dismiss the appeal because, as I indicated earlier, the State C court lacks jurisdiction over the market and thus could not adjudicate the claims of the plaintiff fully. Ultimately, I conclude that the appellate court acted correctly when it dismissed the appeal. So that wraps up a consideration of a straightforward civil procedure problem that raises one or two mildly unconventional issues.